Hi, welcome to TuckerAllen Live. We're here every Friday at 1 o'clock, and today we're here with TuckerAllen attorney Kevin Mason. We're going to be talking about leaving money to minors is our topic for today. TuckerAllen is an estate and elder law firm that practices exclusively in those topic areas, so we're here for when you go through all those stages of life. If you are a young adult just turning 18, just getting married, just having children, if you're in that sandwich generation where you have kids at home, but you're also maybe helping your parents, maybe you're looking at retirement, or the stage where you're looking at long-term care planning and payment for that, we want to be here to help you through all those stages and protect your things. So that's our specialty, and that's where we want to be there to help you. We do invite you to watch all of our other educational presentations. We have lots of them. If you look at our YouTube channel, or if you go to our website and click on the menu resources, you'll see all kinds of webinars and podcasts and educational stuff. I invite you to check those out. So let's get to our topic today. We're talking about leaving money to minors. It's kind of hard to think of a situation where children have lost both parents and are in a place to inherit parents' money, but it does happen. So we want to talk about that. It may also be that you have grandparents that want to leave money to their grandchildren. So parents are still in the picture, but we want to talk about how to safely have grandparents leave money to children. So Kevin, let's talk first about parents leaving money to their kids. Mm-hmm. Many people assume that if they name a guardian for their minor children in their will and something happens to them, that named guardian will just automatically have the inheritance to take care of the children. Is that true?
So that's a kind of a common thing that people believe, but unfortunately it is not true. So what happens whenever the parents, if they name a guardian for their minor children in their will, and then they think that this inheritance that they leave their children will be accessible by that guardian so they can make payments, for education or things like that before the child reaches the age of majority, so 18 or 21 in most states. So what they think is that, okay, there's this inheritance, the guardian will be able to use this for my children's benefit. But what happens is that the guardians, they get the duty of raising the children, but then the court still sticks around, and it's the court's job to hold on to that money, keep it in an account, and then whenever the child does reach the age of majority, they're allowed to disperse it to the child at that point.
So this was a little surprising to me back when I first learned this. What you're saying, that if my husband and I both pass away due to some illness or injury, and we have a will, and we leave the kids, maybe say to my sister, mm-hmm. That my sister does not automatically receive access to our finances in order to pay for the support and care of our children.
No, she will not. So she's not going to get that money. That money is going to be held on to. The court will, set up a bank account. There's different types of bank accounts that they can use, and the court will set up one of those, and they're going to hold that money within the account until the child reaches 18, most likely, and at that point, they're going to disperse the inheritance to the child.
Okay, so there has to be a better solution, right? You're going to tell us about a better solution?
Yes, exactly. So there's a much better solution. So, and the better solution for this situation is certainly like a revocable trust. So,
you watch very many of these Facebook Lives before you start predicting that the answer to a lot of planning challenges is some sort of trust, right? So tell me how it's going to solve this.
So a trust solves this because, like we've talked about before, trust is customizable and we can modify it a lot more. And it also, as I think I've mentioned in about every other Facebook Live, right, that a trust avoid probate. So the court doesn't get involved at all. So it's up to the family and their trustees, the successor trustees, if they choose to kind of make the disbursements. And what can happen with the trust, like a really common thing that will occur, is that I might draft a trust for some younger parents, and we don't know if the children are going to like to spend money a little too much or if they're very frugal. So what we might do is we would set it up to say, okay, let's make the periodic distribution. We'll disperse this money over a 10-year span to keep it in line with the Secure Act, but we'll disperse it over like a 10-year span, and we'll do it over multiple years. And then that way the child gets some money in different increments throughout that time. But the real great thing about a trust is that we have language and every trust like this, that for minors, that we use the terms health, education, maintenance, and support. So what that means is that the trustee, they're holding on to this money until they can disperse it. The child reaches whatever age of inheritance their parents have set. But until that time, the trustee can hang on to these assets. And if the guardian of the children comes over and says, hey, you know, it was their parents' wishes that they go to maybe this parochial school, or one of the children needs braces, or there's lots of things that would fall in this health, education, maintenance, and support language. And then what the trustee can do is they can look at it and say, yeah, absolutely, this is for education, this is for health, and they can disperse some funds from the trust fund for the child in that time. They don't have to wait around, until they reach 18 to get any money.
Right. To help the guardian have the kids live at the level they would have been accustomed to if had their parents not passed away, right?
Absolutely.
You're saying that creating a trust means that the court isn't in control of the money anymore. It goes to the trustee, right?
Yep.
You talked about protecting the money. How does putting it in a trust protect the money from other things like creditors or irresponsible spending? Does it protect those things as well?
Yes. So as long as the assets are in the trust, so like I'll hop on the creditor question first. As long as the money is in the trust, then it's not in possession. If this child had creditors, as long as it's held in the trust, it's not in their possession. So the creditor can't reach it. Once there was a disbursement made to them, if somehow the creditor knew that the disbursement was made, or then they could potentially get some of the money. But as long as it's held in the trust for them, they can't reach that money. And then what was the second question, the part of it?
We hear like irresponsible spending, or
yes.
What if, so for instance, in the scenario we talked about, what if my sister has our children, but she gets a divorce? Is my inheritance going to be a factor in that divorce for my children that she's caring for?
Right. No, luckily it won't have, if your sister got divorced, your inheritance wouldn't have anything to do with that. So it would be separate. It would not, she wouldn't be the trustee, or if she was the trustee, it's still not her asset to be distributing between her and her ex-husband. So it's going to be held there for the children. There's other checks and balances with trust, and that's why there's like fiduciary litigators in this world. I'm not one of them, but there's lots of them. And if somebody was doing something like that, and the penalties for fiduciary litigation are much greater than some of the other things. So there's it's called treble damages, and it's not something people, there's a big stick involved in this.
Right. So what you're saying is if I leave money to my minor children, and the guardian may or may not be the trustee, but they will have access to money to take care of my children, but the money's protected from problems, and so it'll be there when the kids are ready to
yes.
their inheritance.
Yes,
okay.
I think maybe like the main point of think about with the trust is that it makes it to where you can have the periodic distribution for your children as they age. And then the second great thing is that it allows in that health, education, maintenance, and support.
I want to come back to that term periodic distribution, because maybe all of our listeners aren't really clear on exactly what that means.
Okay.
Let's circle back to that. First, though, let's talk about grandparents leaving money to children. So let's say my kids still have us, our parents are still here, but I have elderly parents who want to leave them a little something. What's the best way for grandparents to leave children for minors without making any complications, either for me or for my kids?
Sure. So I would go back to a revocable trust then again, even in this situation. So if we were talking about an asset that's fairly substantial in size, then I would definitely say a trust. If it's a few $1,000s or more, then I would definitely say a trust would be the best way to do that if they're minors, just because of those kind of stipulations that you can put onto it, as well as then we just don't have to worry about any court interference or anything like that with this. Yeah, so it's always going to be easier with minors to run it through a trust and to have a trust in the picture than just a will. So if there is a will, like if in this grandparent situation, there's a will, they left a fairly sizable asset to the child, then again, the court would kind of step in and say, we're going to hang on to this asset for the child. And there's, again, those different bank accounts, and that would be in an account until the child reached 18, and then they would disperse it all to them at that point.
Is that true for assets like leaving a car to a kid, or leaving a share in some property, a tangible property? Is that all the same, or is it handled differently by the court?
So that one is handled a little bit differently by the court, since it's like a tangible. If it was tangible, like a piece of real estate, the child could have ownership of it, but they couldn't sell or do anything with it. They would just hold on to it until they were 18, at which point then they could sell it. So that would be the way that works.
The trustee would still manage that until we decided the trust gave the description about how to give it to the kid.
Yes, absolutely.
Does the trustee and the guardian have to be the same person?
No, I think, for a guardian, that should be someone that you think would raise your children in a manner that you would approve of, and that they're going to respect your wishes. Whereas for the trustee, I think that maybe it's a little bit less important about their personal beliefs, and maybe a little bit more important that they're someone who's very organized and maybe has a little bit of money sense about them.
Yeah, when I think about my family, like I would definitely want to leave my kids to my sister, but I would probably choose someone else to hand my estate to and say, here, make sure all the taxes get paid and everybody gets their distributions and you follow all the little 18 rules and stuff. So,
yes.
So you don't have to be the same person then. That's good to know. Okay. So let's circle back to that term you mentioned. You talked about some terms when you're talking about the value of a trust and rules. And we've talked in Facebooks about different ways you can customize a trust and the value of making it exactly the framework you want it to be for how this estate is passed on. So let's talk about some of those. First, you use the term distribution. So explain to our listeners what that word means. What's distribution?
Sure. So distribution is just an inheritance would be maybe another word for this, but it's the distribution is the act of someone pulling out this asset or this money and kind of handing it to the person who's inheriting it, so the beneficiary. That kind of act is what I would call a distribution. So
the money moves out of an account that I don't have access to in an account that I do have access to, and it basically mine. All right, now you mentioned periodic distribution. So I know there's different kinds of distributions or different rules and frameworks. Tell us a little bit about those.
Sure. So with a will, the only option that you have for distribution, it's always going to be an outright distribution. What I mean by an outright distribution is that as soon as the will is probated, it goes into court and it's probated, then immediately those assets are turned around and they are dispersed. They're handed right back out to the beneficiaries. Whereas, so that's the only way to do it with a will.
Yeah, one big lump all at once.
Right. With a trust, we can do that one big lump all at once, the outright distribution, or another common thing that I do pretty often is called a periodic distribution. And what that is where we can set it up, especially for like minors. Let's say, maybe someone has a child that's young, less than 5 years old or something, and they say, hey, who knows what this child is going to be like? Maybe they'll be very frugal, maybe they won't. And so they're concerned about that. And then one way that we can kind of work together is to say, okay, well, why don't we set up a periodic distribution for this child, maybe whenever they turn, and what I mean by this example, so maybe whenever they turn 20, we'll give them 1/3 of the accumulated trust principal and income that's allocated to them. Then whenever they turn 25, so 5 years later, we might say, okay, we'll give them 1/2 of the remaining trust income and principal that would be allotted to them. And then whenever they turn 30, we say, okay, we'll give them everything that's left that's supposed to be theirs.
And those percentages and ages and everything are totally up to me, right? I can decide how to divide it, what ages they get what.
That was just an easy example.
No, I know that is a common one that we do. Are there other stipulations I can put? Can I say you have to be in school when you're 20 to get this payment, or whatever matters to me? I can add other kind of stipulations to it.
Yes, you can certainly add other stipulations. So not all stipulations that people might like to add are going to be legally enforceable, but some of them would be. So yes, you can put stipulations, and even just putting in the stipulation, even if it isn't legally enforceable, it makes it known what your wishes are and lets that person know what you want.
That makes sense. All right, so it's been helpful to talk about how we hand money to a kid. And some of the things that we need to be aware of and be careful of so we're not creating problems down the road for either our child or the guardians for those children. Thanks for joining us today, Kevin, and nice to talk to you. We're here every Friday at 1 p.m. talking about little estate planning topics. We hope that you learn a lot from those. If there's something you'd like to hear us talk about, feel free to post some questions in the comment box here or go to our website and leave questions. We do town halls live every month and we do Facebook Live every Friday. We'd love to hear if there's a topic you'd be especially interested in hearing us address, or if you just have a question that we could answer for you, we'd welcome that. Give us a call. Have a great Friday and great weekend. Bye, y'all.